our knowledge and expertise with you out there. I also would like to acknowledge the traditional owners on the land that we meet, the Wathaurong people, and honour and pay our respects to their elders past and present. And that is based here where the hosts are tonight in Geelong. A little bit of housekeeping really quickly, as we talked about. Yep, camera off, mic off. Please communicate through the chat option. We've got a bit of a chat option going on at the moment. So please interact through that, ask any questions that you would like, and we will do our best to get those questions through to Paul, interact through that conversation as well. Also, the sessions will be recorded. We will share the recordings post-session on one of our websites that will allow you to go through and connect in with that. Just briefly, a bit about Leisure Networks. So we're a regional sports assembly based in Geelong. We also service Metro Melbourne as well. Our purpose is to connect people with community, and particularly in this case, providing support to grassroots sport and participation. So that's why we've connected with you here tonight. Pretty much the forum, we want this to be short, sharp, efficient, effective for everyone. We want you all to stay online the whole time, so we need to keep it nice and interactive. The first 10 to 15 minutes will be Paul Gray presenting. He will be presenting his content on the back of Howard Andrews and his expertise. Then after that, there'll be a 20-minute Q&A, which Paul has received all questions from everyone that's registered. He will pretty much just roll question after question after question after question. And answer after answer. So that's pretty much how that'll work. And the reason for that is we don't want 60 people asking questions in a 30-minute period. Paul answer as many as he can. I will also collate all the questions as well and throw them to Paul. If they are not answered, we have your email address and we will email them through with any comments and any notes from tonight. Yep. So what I would like to do now and jump pretty much straight into it is introduce Paul Gray, who's a principal at Howard Andrews here in Geelong. He brings a commercial approach to the law from a broad self of experience as a business owner, private legal advisor and in-house counsel. And having worked with management teams over many years, Paul is valued for focusing on issues down to what is really important and being prepared to make a risk call based on judgment and experience. So what I would like to do now is introduce Paul Gray to take over this this presentation, and I'd like you all to welcome Paul as well. Thanks, Paul.
Thanks, Michael, and hopefully everyone can hear me. I don't get that bio read out very often anymore, so thanks for that. But thanks, appreciate the opportunity to come in and talk to everyone. We've done work with Leisure Networks over many years, and through our offices in Melbourne and Geelong, support a lot of clubs and organisations around the place. So today, and I'll share some content with you briefly in a second. There we go. Okay, so look, there's been a lot happening in the last month, and to think, 6 weeks ago we're all sitting in cafes, drinking lattes together. We've seen a lot of change, obviously, and today, there's a whole lot of generic and general information that's out there, and you probably can access. And I don't really want to overload you with that. I think this evening, all I really want to do is run through a bit of a checklist for you, a bit of an approach to how to think about your contracts that are in place in these sorts of circumstances. So we'll talk through that framework, and then some of the options available for you, and some of the things to look out for. By definition, the answer to a lot of my questions is going to be it depends on the terms of the contract. But I think if I can provide a framework with you and a way to think about the contracts you have in place and an opportunity to take a step forward from from where you are now, I think that's a win. And then we can deal with some more specific stuff in the back half. So where do we all come from? We've seen the National Cabinet meeting. there's a state of emergency declared in Victoria. A lot of the questions we've been asking, we've been talking to clients about is, well, what's the legal basis of all this, and how is it starting to impact the relationships that I have and the contracts I have. Certainly, the National Cabinet provides a bit of a, arguably, I guess, a national view on things, but from a legal perspective, in Victoria in particular, the main thrust of that is through directions under the Public Health Act, and I've posted a link to those if those people are interested. I've posted a link to the page in the chat that lists all the directions that come out of the state government under the Public Health Act, and that actually has the text of the directions themselves. Usually what you'll see through the media is a summary of that or a highlights of that. If you are interested and you are particularly impacted, it's worthwhile going and actually having a look at the directions themselves, and they're not lengthy documents. Basically, the public health officer has the ability to go and do that under the state of emergency. So that's kind of where we're at from a contractual perspective. Obviously, there's some big health concerns as well, and we'll touch on that in the next 10 or 15 minutes, both from an individual personal perspective, how we change our behaviour, and for employers, there is some OH&S issues for their staff as well. So I just want to start with the idea of analysing your contracts. So the analysis of your contract should probably start with what's your role here? Are you a customer or a supplier? And the recommendation here is to get a list of your contracts out and start putting them into a bit of a framework, and it helps you start thinking through what to do next. Contract principles don't go out the door in a COVID crisis. Although there's, contracts that, we would like to think are designed to cover all bases and be taken out of the bottom drawer when things go wrong. COVID-19 has certainly put the heat on a lot of lawyers and people who have thought they had all their bases covered, thinking, oh my goodness, what am I going to do here? Whatever I've written on the paper doesn't seem to cater for that. And that might be the case, but it's also the case that contract principles don't go away, and we're sort of stuck with what we've got from, what we've got on the piece of paper. So I guess the first message here is, contract principles will continue to apply, and the question is, how do we deal with what you've got in your contract? So the framework that we're suggesting is really just to think about 4 factors for each of the contracts that are in place. And when I say contracts, I mean quite literally go and dig out the bit of paper that sets out what you've got in place between yourselves and either your members or your customers and suppliers, and we'll talk about different aspects of that in a second. And if you don't have a piece of paper, what is in place, what sort of agreement or contract, the contracts can be verbal as well, what's the arrangement that you have in place? And have a think about whether the first question really is, are you supplying something or are you buying something? And the implications of this will become clearer a little bit later. The next question for each contract is who is really impacted here? Do you have an inability to pay a supplier, for instance, or are you meant to be providing a service to someone and you no longer can because of some reason in the current circumstances? The next question then is, what's the trigger? What's the reason why that obligation can't be performed? And do have a think about this, because it does impact some of your contractual rights. Some businesses are directly impacted by the directions under the Public Health Act. If you are a gym or operate a fitness centre, for instance, you've basically been directed to close. It's pretty clear. But a lot of other businesses are not directly impacted by a direction. They could be simply a victim of people's changed behaviour. They may need to change the way they deliver their service virtually rather than in person, or various other mechanisms. So have a think about what's the trick, what's the reason that the obligation's impacted, and then have a think about which party. Is it you, or is it the other party that's really preventing this from happening? And we've seen a lot of cases where really it's both parties, but from a contractual perspective, it's important to sort of drill down and think, well, who is the party being prevented here? And it's worthwhile having a think around that. Okay. And once you've got your little framework, then you can start thinking through some of the options and the issues that may arise. And there's really about 4 or 5 issues I want to talk through at a pretty high level. The first one is around force majeure. The second one around frustration. I want to touch on Australian consumer law and the right to, and potentially the right to suspend services. I think it's important we talk about OH&S, particularly for those with employees, and more generally, how do we deal with employees? So the go-to place in most contracts in these sort of circumstances is a force majeure clause, and a force majeure is effectively a contractual clause that says, you know, if certain things happen, and you will have seen language like, you know, things like act of God or pandemics or riots or basically things outside the control of the parties that are very, very unlikely, then the obligations of the parties can be suspended for a certain period of time. You'll get sick of me saying it depends on the terms of the contract, but in a force majeure clause, if there is one in your contract, it really depends on, again, whether you're the supplier or the customer here. For suppliers, force majeure clauses have been their friend for many years. It means that, you know, if something strange happens like this, they can basically say, no, it's okay, all bets are off, we'll just put everything on pause until this force majeure passes. Interestingly, in this sort of circumstance, force majeure clauses are also coming to the assistance of customers as well, because customers, particularly those with cash flow issues who don't want to continue to provide that service, may be very happy that their supplier calls for force majeure, which means not only do they cease getting the service, but they also cease having to pay. The trick, of course, is that the other option, which is some sort of suspension of service by the customer, means that what we're seeing a lot of in this in the last couple of weeks, relationships where it's almost a bit of game of chicken going on as to which party will call an end to the provision of services, because very often it is depending on who makes the first call, they are the people that will start bearing the cost of that suspension. So it's very important that if you do think you might have to cancel something, or you're pondering the need to suspend services of your suppliers, that you do have a look at the contract and see what rights you have. Very often contracts will give customers the right to tell their subcontractors to pause, but the cost of that pause is often borne by the customer. The same contracts will also have a force majeure clause that may allow the supplier to say pause as well. And for a customer, a lot better for the supplier to say force majeure than to suspend the service and bear the cost of the supplier as well during that pause. If you do want to think about force majeure rights, there are usually notice provisions. There are usually an assessment of what trigger events you can actually use it for. And there will generally be a requirement to mitigate your loss as well. So do have a think about those things if you want to go down that path. You may have also heard about the possibility of terminating or walking away from a contract due to the doctrine of frustration. This, if successful, brings a contract to an end in circumstances where an intervening event has occurred through no fault of the parties and makes a contractual obligation impossible to perform. Seems to fit the tenor of the circumstances really, but frustration has a very narrow scope. It doesn't arise where there's been mere hardship, even if severe, and if the event is only temporary or transient, which potentially, depending on the contract, might be the case in relation to COVID-19. Look, courts have found that frustration has arisen in potentially relevant circumstances. For instance, a fundamental change in the basis of the contract. If you're running a competition that isn't happening this year and the contract is in relation to that competition, well, there's a fundamental change in the basis of the contract. And arguably frustration could be argued. If you're on the other side and someone has sought to argue force majeure or frustration, then obviously you can contest that claim and argue that they don't apply. Again, will depend on the circumstances, but it's not as though it's a simple lay down majeure if these sort of clauses are there. I do want to talk really briefly about the Australian consumer law as well. For most organisations, if they're considered, particularly clubs, might be considered small businesses, but certainly your relationship with many of your members, unless they're actual members of an organisation, i.e. they are members under a constitution. If you're just providing services to people, you're more than likely are consumer contracts. And the ACCC has been quite active in this space. You will have seen some of their commentary around what their expectations are for businesses dealing with consumers, and the same would go in the sports industry, along with the general obligations to not mislead, to not act unconscionably, and not to seek to rely on unfair terms. There are other obligations that they've talked about around, taking payments when there's no reasonable expectation of an ability to supply a service is contrary to the Australian consumer law. And there's actually some quite good guidance, if you're interested, on the ACCC website around things like cancellation of functions and events. Whether you can rely on a contractual term that allows you to keep your a deposit or a prepayment up front, and that sort of thing. It'd be remiss of me to not deal briefly in relation to the OH&S issues. As employers, you all have an obligation to look after your employees, and that is something that is ongoing even in a COVID-19 circumstance. So do have a think about taking steps as far as reasonably practicable to have your workplaces without health and safety risks, and in the COVID-19 environment, we would expect that employees would at least be providing information about health risks posed by contact with COVID-19, providing instructions about ways to minimise those risks, and do appropriate monitoring, assessment, and taking steps to mitigate any risks that you identified. Things we've seen that a lot of employers are taking include not only just staying up to date, and there's heaps of information out there, rely on state and federal health departments, would be the best place to go. Share that information with your employees. Restricting travel as something that was done quite early on, as well as providing adequate hygiene facilities, etc. There's also been a lot of conversation around ability to access schemes like JobKeeper. Probably outside the scope of this conversation tonight to go into detail, but ultimately eligible businesses can access a wage subsidy of $1,500 a fortnight for each eligible employee from 30th of March. And there are a number of eligibility tests, as well as a bunch of quite useful flexibilities under the Fair Work Act as to how you deal with your workforce. So the ability to stand down employees, unilaterally reduce employees' hours, change duties, etc., which normally you wouldn't be able to, but once you qualify for JobKeeper, it does provide you with a great deal of flexibility within the workplace. So again, encourage you to look into that if that would be something that is for you. You will have seen the turnover test of a 30% reduction in a comparable period as sort of the threshold for eligibility for employers. That's not as simple as it sounds, particularly for bigger groups, but particularly for smaller organisations, it's something worth considering. Okay, I was going to talk about a couple of examples that people raised and questions. So first of all, just talking generally about members, members of sporting organisations sort of fall into two buckets. They fall into people who sign up as a member of the organisation entity itself and who hold a membership and i.e. associated rights to vote, perhaps with the association, and also the other bucket of people who I guess they acquire a service from the organisation. They're not necessarily a member. They might not have a right to vote and no rights under the Constitution. Either way, there's a contract there, and when you are considering what to do with members subscriptions and members fees, that's the place to start. What is the service, or what is the contract in place between you and your members for the money that they've paid? I think it's a really vexed issue, and we've seen this play out in the education space as well, where people are paying school fees, for instance, for a service that is a little different to what they signed up for. Let's say my kid can't go to school, they're sitting at home on the computer, or for the 15 minutes of concentration they have, that isn't exactly the school day that or the service that I'm purchasing. Same in a sports environment. All of a sudden, I can't go to training, I can't play games. What is my membership buying me? And I think this is where you can get some inspiration from the ACCC. They've provided some really helpful guidelines around sort of the hard limits of this. But the conversation we've been having with clients in this space is really around, well, what service are you providing? What is the content? What is the value of what people have bought? And how can you add value to that in these circumstances? How can you, I guess, either suggest that this is more a donation to the organisation for this season, or can we defer it? Is a refund actually required, either under the law or morally? These are good conversations to have in the context of a good understanding of what the contract is between yourself and your members. I do want to talk about event cancellations as well. Look, event cancellations have happened everywhere. Going back to our initial list, if the event cancellation is due to government restrictions, the Australian consumer law wouldn't suggest that a refund is strictly necessary, but you'd still be required to honour your existing terms and conditions. What were the terms and conditions of the ticket that was purchased, or the membership that was associated with it? The relevant terms and conditions are those in effect at the time that your customer made the booking, or the member made the booking for the event. You can't retrospectively change them, and Australian consumer law aside, the contractual principles that will apply in any event will continue to apply, and they may have rights under the contract that you have with them. The guidance here has been to really seek to agree to some other remedy, really. You can provide a partial refund, a credit note or a voucher, or agreeing to postpone the service until a later date if possible. The guidelines also suggest that if you do provide credit notes or vouchers, that expiration date needs to be long enough for them to actually use the thing. The other one is in relation to upfront payments. So people have paid up front for something that's not going to be delivered. Look, it's usually a bit of a fraught one. Again, depends on the terms of the contract, but in many circumstances, even a term that allows you to retain a full deposit would be considered unfair under this unfair contracts legislation. And it may not, I guess the question is it reasonably necessary for you to retain the full amount to protect your legitimate business interests? You know, what costs are actually being incurred by the cancellation? And lastly, I was just going to touch really briefly on options for renegotiation. So the big message in these sort of circumstances, particularly when you're out of options in the body of the contract, is to communicate honestly and openly with the other side on a contract. And and it really depends on the nature of the contract. For instance, commercial leases will now have a legislative regime you can work within, and I expect that retail tenancies, etc., will also have a more clarity on the regime that you can use to guide the negotiations between contracting parties over the next little while.
Hey, Paul, just quickly, was there a slide that was relevant to that? Just a comment there around showing the slide that was relevant. Was there a question slide there? Is that slide 4 that you wanted to show?
That was it, actually. Yep. So the 3.
Yep. All good. All good.
So yep, I'm good. That was kind of the summary. Happy to have a conversation.
Yep. Just a couple of questions here, Paul. We've got 10 minutes to go. So sure. Just there's a question here around clubs that have already taken membership. So if a club's taken membership, and that's an income for the club, but then members are now asking for refunds. Yep. Have you got any advice for those? And I think this is a very common question out there.
Yeah, and I think it comes to that where I finished up there around cancellation of events. I think the same principles really apply here. Ultimately, what is the membership? First of all, my first question will be, what have people bought as part of that membership? Are they buying a set of benefits? Are they buying access to club rooms? Have a think about what that membership gets you. And I think that once you've got that in train, you can then say, well, what can't I provide as part of that membership for that membership fee? I think that's the beginning of a conversation with your members to say, hey, look, I can't provide some of these things for this season. but it's really important for the club to continue to operate, and we're going to continue to provide the things we can, and perhaps think of some other ones, added benefits if you can and are able to basically pump the value up to see if you can retain as much as that as you can.
Yeah. Another question here around advice. A sporting code has employed a coach or has a coach contract. Is similar to membership, I suppose, but they become an employee of the club that would have some sort of contract. Any advice around having those conversations on whether or not you pay? I don't know. You pay some fee, a pro rata, or you can cease the contract.
Yeah, it depends on the contract, but broadly, the question is are they a contractor or an employee? If they're an employee, there is the ability to, in some circumstances, to stand those employees down. It's worth getting some good advice about this sort of stuff. But basically, you can, if you shut down your operations for a period of time and the employees cannot be usefully employed, the employer can rely on stand-down provisions containing the Fair Work Act. Now, a stand-down is effectively the person remains an employee, but isn't paid and doesn't need to come to work. It's amazingly rarely used until COVID-19. Actually, it's a bit of a dusty provision of the Fair Work Act that that's got a lot of airtime in the last month or so. Any such direct, you can also ask employees to take annual leave or other forms of leave, depending on your modern award or enterprise agreement in place. But for both, the direction's got to be reasonable, and there are specific requirements that will apply, including providing advance notice. So if that is an option, and obviously there are also the options, and you will have seen some press around this sort of thing where organisations have asked, basically come to an agreement with their employees to say, look, things have changed, to help save the organisation. Is everyone happy to take a 20% pay cut? Now that's got to be by agreement, but the implication here is that if the agreement isn't reached, then perhaps more drastic measures might be required to save the organisation. Therefore, have those conversations with your employees like that as well.
Yep. Next question, just around contracts again. Obviously, from a player point of view, clubs go into contracts with players. So if we're in a pause phase at the moment, do we have the legal ability to ask athletes to continue to train and keep themselves in peak condition, considering there's potentially a break in a contract with nothing happening?
Yeah, it's interesting. So employees, if they continue to be employees, they can't really refuse to come to work, unless there's sort of an unreasonable risk to their health or safety. They've got to have a valid basis for refusing. So ultimately, I would have thought if you've engaged a player and you want them to continue to perform their obligations under their contract, it's not as though they can refuse unless there's, as I said, there's a reasonable risk to their health and safety.
If it's local level speaking, they're just a local player that has a contract, not an employee. Is that the same case or different conversation again?
Depends on the nature of the arrangement. So if a contract is sort of a fee for a game,
yep.
Probably have to have a look at the terms of it, but conceptually you would need to have a think about whether they're an employee or not, even a casual type employee. So yeah.
Yep. If the coach has a service provider contract to provide coaching services and the club is shut down, therefore until unable to provide their services, would it be unreasonable to ask the coach to pay the club any sort of fee? And if the coach is asked to pay a fee and refuses, can their contract be terminated?
I'm not too sure. So has the coach got to pay a fee? Usually the club pays the coach. Is that?
Yeah, so if the coach has a service provider contract to provide coaching services and the club is shut down,
Okay,
yeah,
gotcha.
yeah,
So I say almost like a hiring type arrangement to
yeah,
use the facilities to run a business.
yeah,
Uh, Again, depends on the arrangement. With those sorts of things, I imagine the coach is an independent business. It's effectively a hiring type arrangement, perhaps, or use of facilities. If the club can't provide the facilities, I think this goes back to one of our first conversations about what does the contract say? Does it have a force majeure clause? Why can't the club provide the facilities? If they can't provide the facilities because of a direction by the state government or other health-related concerns, they may be able to rely on a force majeure clause to pause it. But if I would have thought that on basic principles, if I was a coach and unable to access facilities that I'm paying for, I wouldn't be expected to pay for them. I think that's a hard one, but you'd want to have a look at the contract.
yeah. So what I'll do there, everyone. This is obviously all recorded. All questions that are coming through. If there's any further questions, please send them through to us. If you think about it over the next 24 hours, please send that through, and we'll get that to Paul Gray, and we'll get that back out to everyone as well. So what I wanted to just quickly touch on then is just some final comments here, which I believe clubs are well protected during this time, and clubs have lots of rights and responsibilities. Probably the biggest thing is to ensure that we refer back to that club, that framework that Paul discussed earlier on, and we'll share those slides with everyone as well, which is really important. The last thing I just wanted to touch on for everyone here too is just the Club Help website. So what we're going to be doing with a lot of these forums is we're going to get our forums and our content up on the Club Help website there as well. So for anything further, please access that. There's a lot of support there for clubs, financial, legal support, and a number of other range of areas as well. But I wanted to thank everyone so much for coming on board tonight. Like I said, any questions, please send it through. But it is 7:44, and we plan to make these nice and effective and efficient, and we have done so to make sure that we're making good use of your time out there. So I just wanted to say a big thank you to Paul Gray for donating his time on behalf of Harwood Andrews. A big thank you to you. Big thank you to everyone out there for coming online. This is one of 4 seminars. There's one on Thursday night around financial management for clubs, hosted by Moore Stevens. So if you're on that forum, this is how it'll run, very similar. If you're not on the forum, please let us know if you'd like to. We do have a wait list, but we will add more people in. But lastly, yeah, thank you to everyone out there. You're doing a great job. Hopefully Paul answered a number of questions. And please stay connected to us and stay connected to the community in the industry. You're all doing a fantastic job out there. And on behalf of Leisure Networks and the other partners, I'd like to thank everyone for tonight.
Thanks, Michael. Well done.
Thanks, guys.
Thank you.
Thank you.
Thank you.